Bush v. Gore, 531 U.S. 98, 2000, was a decision of the United States Supreme Court resolving the dispute surrounding the 2000 presidential election. The ruling was issued on December 12, 2000. On December 9, the court had preliminarily halted the Florida recount that was occurring. 8 days earlier, the court unanimously decided the closely related case of Bush v. Palm Beach County Canvassing Board, 531 U.S. 70, 2000. The Electoral College was scheduled to meet on December 18, 2000, to decide the election. In a per curiam decision, the court ruled that there was an Equal Protection Clause violation in using different standards of counting in different counties and ruled that no alternative method could be established within the time limit set by Title III of the United States Code, 3 U.S.C. 5, Determination of Controversy as to Appointment of Electors, which was December 12. The vote regarding the Equal Protection Clause was 7-2, and regarding the lack of an alternative method was 5-4. 3 concurring justices also asserted that the Florida Supreme Court had violated Article 2, 1, CL2 of the Constitution, by misinterpreting Florida election law that had been enacted by the Florida legislature. The Supreme Court decision allowed the previous vote certification to stand, as made by Florida Secretary of State Katherine Harris, for George W. Bush as the winner of Florida's 25 electoral votes. Florida's votes gave Bush, the Republican candidate, 271 electoral votes, one more than the required 270 to win the Electoral College, and the defeat of Democratic candidate Al Gore, who received 266 electoral votes. A faithless elector from the District of Columbia abstained. Media organizations subsequently analyzed the ballots and found that the originally proposed county-based recounts would have resulted in a different outcome, Bush victory, than a full statewide recount, Gore victory. Florida subsequently changed to new voting machines to avoid punch cards which had allowed dimpled cards or hanging chad. Background. In the United States, each state conducts its own popular vote election for president and vice president. The voters are actually voting for a slate of electors, each of whom pledges to vote for a particular candidate for each office, in the Electoral College. Article 2, 1, CL2 of the U.S. Constitution provides that each state legislature decides how electors are chosen. Early in U.S. history, most state legislatures directly appointed the slate of electors for each of their respective states. Today, state legislatures have enacted laws to provide for the selection of electors by popular vote within each state. While these laws vary, most states, including Florida, award all electoral votes to the candidate for either office who receives a plurality of the state's popular vote. Any candidate who receives an absolute majority of all electoral votes nationally, 270 since 1963, wins the presidential or vice presidential election. On November 8, 2000, the Florida Division of Elections reported that Bush won with 48.8% of the vote in Florida, a margin of victory of 1,784 votes. The margin of victory was less than 0.5% of the votes cast, so a statutorily mandated automatic machine recount occurred. On November 10, with the machine recount finished in all but one county, Bush's margin of victory had decreased to 327. According to legal analyst Jeffrey Toobin, later analysis showed that a total of 18 counties accounting for a quarter of all votes cast in Florida did not carry out the legally mandated machine recount, but no one from the Gore campaign ever challenged the notion that the machine recount had been completed. Florida's election laws allow a candidate to request a county to conduct a manual recount, and Gore requested manual recounts in 4 Florida counties, Volusia, Palm Beach, Broward, and Miami-Dade, which are counties that traditionally vote Democratic and would be expected to garner more votes for Gore. Gore did not, however, request any recounts in counties that traditionally vote Republican. The 4 counties granted the request and began manual recounts. However, Florida law also required all counties to certify their election returns to the Florida Secretary of State within 7 days of the election, and several of the counties conducting manual recounts did not believe they could meet this deadline. On November 14, the statutory deadline, the Florida Circuit Court ruled that the 7-day deadline was mandatory, but that the counties could amend their returns at a later date. The court also ruled that the Secretary, after considering all attendant facts and circumstances, had discretion to include any late amended returns in the statewide certification. Before the 5 p.m. deadline on November 14, Volusia County completed its manual recount and certified its results. At 5 p.m. on November 14, Florida Secretary of State Katherine Harris announced that she had received the certified returns from all 67 counties, while Palm Beach, Broward, and Miami-Dade counties were still conducting manual recounts. Harris issued a set of criteria by which she would determine whether to allow late filings, and she required any county seeking to make a late filing to submit to her, by 2 p.m. the following day, a written statement of the facts and circumstances justifying the late filing. 4 counties submitted statements, and after reviewing the submissions, Harris determined that none justified an extension of the filing deadline. She further announced that after she received the certified returns of the overseas absentee ballots from each county, she would certify the results of the presidential election on Saturday, November 18, 2000. On that date, she certified Bush the winner and litigation ensued. Stay of the Florida recount. By December 8, 2000, there had been multiple court decisions regarding the presidential election in Florida, and on that date the Florida Supreme Court, by a 4-3 vote, ordered a statewide manual recount. On December 9, the U.S. Supreme Court voted 5-4 to stay the Florida recount, because according to Justice Scalia, it suffices to say that the issuance of the stay suggests that a majority of the court, while not deciding the issues presented, believe that the petitioner has a substantial probability of success. The issue is not, as the dissent puts it, whether counting every legally cast vote can constitute irreparable harm. One of the principal issues in the appeal we have accepted is precisely whether the votes that have been ordered to be counted are, under a reasonable interpretation of Florida law, legally cast vote. The counting of votes that are of questionable legality does in my view threaten irreparable harm to petitioner Bush, and to the country, by casting a cloud upon what he claims to be the legitimacy of his election. Count first, and rule upon legality afterwards, is not a recipe for producing election results that have the public acceptance democratic stability requires. The dissenters opined. Counting every legally cast vote cannot constitute irreparable harm. Preventing the recount from being completed will inevitably cast a cloud on the legitimacy of the election. The 4 dissenting justices argued that stopping the recount was an unwise violation of 3 venerable rules of judicial restraint, namely respecting the opinions of state supreme courts, cautiously exercising jurisdiction when another branch of the federal government has a large measure of responsibility to resolve the issue, and avoiding making peremptory conclusions on federal constitutional law prior to a full presentation on the issue. Rapid developments. The oral argument in Bush v. Gore occurred on December 11. Theodore Olson, a Washington, D.C. lawyer and future Solicitor General, delivered Bush's oral argument. New York lawyer David Boies argued for Gore. During the brief period when the U.S. Supreme Court was deliberating on Bush v. Gore, the Florida Supreme Court provided clarifications that the U.S. Supreme Court had requested on December 4 in the case of Bush v. Palm Beach County Canvassing Board, 531 U.S. 70, 2000. Because of the extraordinary nature and argued urgency of the case, the U.S. Supreme Court issued its opinion in Bush v. Gore on December 12, 2000, less than a day after hearing oral argument. Relevant law. The Equal Protection Clause of the 14th Amendment, on which the decision in Bush v. Gore was based, states, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Article 2, 1, CL2 specifies the number of electors per state, and, most relevant to this case, specifies the manner in which those electors are selected, stipulating that each state shall appoint, in such manner as the legislature thereof may direct, a number of electors. This clause arguably gives power to only one branch of Florida state government, i.e., the state legislature. 3 U.S.C. 5 regulates the determination of controversy as to appointment of electors in presidential elections. Of particular relevance to this case was the so-called safe harbor provision, which allows states to appoint their electors without congressional interference if done by a specified deadline. If any state shall have provided, for its final determination of, the appointment of all or any of the electors of such state, at least 6 days before the time fixed for the meeting of the electors, such determination, shall be conclusive. Since the electors were set to meet December 18, the safe harbor deadline was December 12, just 1 day after the court heard oral arguments in this case. According to 28 U.S.C. 1257. Final judgments or decrees rendered by the highest court of a state in which a decision could be had, may be reviewed by the Supreme Court by writ of certiorari where the validity of a treaty or statute of the United States is drawn in question or where the validity of a statute of any state is drawn in question on the ground of its being repugnant to the Constitution, treaties, or laws of the United States. Issues considered by the court. The court had to resolve 2 different questions to fully resolve the case. Were the recounts, as they were being conducted, constitutional? If the recounts were unconstitutional, what is the remedy? 3 days earlier, the 5-justice majority had ordered the recount stopped and the court had to decide whether to restart it. Equal Protection Clause. Bush argued that recounts in Florida violated the Equal Protection Clause of the 14th Amendment, because Florida did not have a statewide vote recount standard. Each county was on its own to determine whether a given ballot was an acceptable one. 2 voters could have marked their ballots in an identical manner, but the ballot in one county would be counted while the ballot in a different county would be rejected, due to the conflicting manual recount standards. Gore argued that there was indeed a statewide standard, the intent of the voters standard, and that this standard was sufficient under the Equal Protection Clause. Furthermore, Gore argued that the consequence of ruling the Florida recount unconstitutional simply because it treated different voters differently would effectively render every state election unconstitutional and that each method has a different rate of error in counting votes. A voter in a punch card county has a greater chance of having his vote undercounted than a voter in an optical scanner county. If Bush wins, Gore argued, every state would have to have one statewide method of recording votes to be constitutional. Remedy. This was the most closely decided issue in the case. The arguments presented by counsel did not extensively address what the court should do if the court were to find an equal protection violation. However, Gore did argue briefly that the appropriate remedy would not be to cancel all recounts, but rather would be to order a proper recount. Article 2. Bush also argued that the Florida Supreme Court's ruling violated Article 2, 1, CL2 of the U.S. Constitution. Essentially, Bush argued that the Florida Supreme Court's interpretation of Florida law was so erroneous that their ruling had the effect of making new law. Since this new law had not been directed by the Florida legislature, it violated Article 2. Bush argued that Article 2 gives the federal judiciary the power to interpret state election law in presidential elections to ensure that the intent of the state legislature is followed. Gore argued that Article 2 presupposes judicial review and interpretation of state statutes, and that the Florida Supreme Court did nothing more than exercise the routine principles of statutory construction to reach its decision. Decision. In brief, the breakdown of the decisions was: 7 justices, the 5-justice majority plus Souter and Breyer, agreed that there was an Equal Protection Clause violation in using different standards of counting in different counties. 5 justices agreed that December 12, the date of the decision, was the deadline Florida had established for recounts, Rehnquist, O'Connor, Scalia, Kennedy, and Thomas in support, Stevens, Souter, Ginsburg, and Breyer opposed. Justices Souter and Breyer wanted to remand the case to the Florida Supreme Court to permit that court to establish uniform standards of what constituted a legal vote and then manually recount all ballots using those standards. 3 justices, Rehnquist, Scalia, and Thomas, argued that the Florida Supreme Court had acted contrary to the intent of the Florida legislature. 4 justices, Stevens, Souter, Ginsburg, and Breyer, specifically disputed this in their dissenting opinions, and the remaining 2 justices, O'Connor and Kennedy, declined to join Rehnquist's concurrence on the matter. Equal Protection Clause. The Supreme Court, in a per curiam opinion, ruled that the Florida Supreme Court's decision, calling for a statewide recount, violated the Equal Protection Clause of the 14th Amendment. This ruling was by a 7-2 vote. The court held that the Equal Protection Clause guarantees to individuals that their ballots cannot be devalued by later arbitrary and disparate treatment. Even if the recount was fair in theory, it was unfair in practice. The record, as weighed by the Florida Supreme Court, suggested that different standards were seemingly applied to the recount from ballot to ballot, precinct to precinct, and county to county, even when identical types of ballots and machines were used. According to the court, the statewide standard, that a legal vote is one in which there is a clear indication of the intent of the voter, could not guarantee that each county would count the votes in a constitutionally permissible fashion. The court stated that the per curiam opinion's applicability was limited to the present circumstances, for the problem of equal protection in election processes generally presents many complexities. Remedy. The court ruled 5-4 that no constitutionally valid recount could be completed by a December 12 safe harbor deadline. The court asserted that the Supreme Court of Florida has said that the legislature intended the state's electors to participate fully in the federal electoral process, as provided in 3 U.S.C. 5. The court therefore effectively ended the proposed recount, because the Florida legislature intended to obtain the safe harbor benefits of 3 U.S.C. 5. 4 justices, Justices Stevens, Ginsburg, Souter, and Breyer, dissented as to stopping the recount. 2 of those 4 dissenters, Justices Breyer and Souter, acknowledged that the counting up until December 9 had not conformed with equal protection requirements. However, Souter and Breyer favored remanding the case back to the Florida Supreme Court for the purpose of crafting specific guidelines for how to count disputed ballots, in contrast to the majority's decision to halt the recount altogether. The actual counting had ended with the December 9 injunction issued by the same 5-justice majority, 3 days before any deadline. The dissenting opinions strongly criticized the 5-justice majority for involving the court in state-level affairs. Justice Stevens' dissent, joined by Justices Breyer and Ginsburg, concluded as follows. What must underlie petitioners' entire federal assault on the Florida election procedures is an unstated lack of confidence in the impartiality and capacity of the state judges who would make the critical decisions if the vote count were to proceed. Otherwise, their position is wholly without merit. The endorsement of that position by the majority of this court can only lend credence to the most cynical appraisal of the work of judges throughout the land. It is confidence in the men and women who administer the judicial system that is the true backbone of the rule of law. Time will one day heal the wound to that confidence that will be inflicted by today's decision. One thing, however, is certain. Although we may never know with complete certainty the identity of the winner of this year's presidential election, the identity of the loser is perfectly clear. It is the nation's confidence in the judge as an impartial guardian of the rule of law. The per curiam opinion in Bush v. Gore did not technically dismiss the case, and instead remanded for further proceedings not inconsistent with this opinion. Gore's attorneys therefore understood that they could fight on, and could petition the Florida Supreme Court to repudiate the notion that December 12 was final under Florida law. However, Gore dropped the case, because he was not optimistic about how the Florida justices would react to further arguments and, as one of his advisors put it, the best Gore could hope for was a slate of disputed electors. In addition to this, Gore campaign chairman Bill Daley argued that fighting on was futile because even if the Florida Supreme Court defied the U.S. Supreme Court and ordered a new recount, GOP would take them straight back to Washington, where the Supreme Court would repeat, "You ain't going to count, okay? So quit bothering us." On remand, the Florida Supreme Court issued an opinion on December 22, 2000, that did not dispute whether December 12 was the deadline for recounts under state law, although this was disputed in a concurring opinion by Florida Supreme Court Justice Leander Shaw, who nevertheless expressed deference to the U.S. Supreme Court's view on this issue and who also argued that, in any case, the Florida Supreme Court would, in his opinion, be unable to craft a remedy which would satisfy all of the U.S. Supreme Court's equal protection, due process, and other concerns. Article 2. Chief Justice Rehnquist's concurring opinion, joined by Justices Scalia and Thomas, began by emphasizing that this was an unusual case in which the Constitution requires federal courts to assess whether a state Supreme Court has properly interpreted the will of the state legislature. Usually, federal courts do not make that type of assessment, and indeed the per curiam opinion in this case did not do so. After addressing this aspect of the case, Rehnquist examined and agreed with arguments that had been made by the dissenting justices of the Florida Supreme Court. Scholarly analyses. Bush v. Gore prompted many strong reactions from scholars, pundits, and others over the court's decision. The critical remedial issue. The most closely decided aspect of the case was the key question of what remedy the court should order, in view of an Equal Protection Clause violation. Gore had argued for a new recount that would pass constitutional muster, but the court instead chose to end the election, asserting that the Florida Supreme Court has said that the Florida legislature intended to obtain the safe harbor benefits of 3 U.S.C. 5. This assertion in Bush v. Gore has proven very controversial. Michael W. McConnell has written that the U.S. Supreme Court's decision on December 12 may have reached the right result for the wrong reason. McConnell points to the Florida Supreme Court's December 11 opinion, which characterized December 12 as an outside deadline. Here is the pertinent excerpt from the December 11 opinion of the Florida Supreme Court. What is a reasonable time required for completion will, in part, depend on whether the election is for a statewide office, for a federal office, or for presidential electors. In the case of the presidential election, the determination of reasonableness must be circumscribed by the provisions of 3 U.S.C. 5, which sets December 12, 2000, as the date for final determination of any state's dispute concerning its electors, for that determination to be given conclusive effect in Congress. As always, it is necessary to read all provisions of the Elections Code in pari materia. In this case, that comprehensive reading required that there be time for an elections contest pursuant to Section 102.168, which all parties had agreed was a necessary component of the statutory scheme, and to accommodate the outside deadline set forth in 3 U.S.C. 5 of December 12, 2000. However, according to Nelson Lund, one might argue that the Florida Supreme Court was discussing the protest provisions of the Florida Election Code, whereas the issues in Bush v. Gore arose under the contest provisions. Likewise, Peter Berkowitz has written that, perhaps it would have been more generous for the court to have asked the Florida court on remand whether outside deadline referred to contest period as well as protest period recounts. Abner Green has pointed to evidence that the Florida Supreme Court thought all manual recounts, whether protest or contest, must be completed no later than December 12. Nevertheless, Green concluded that, lack of clarity about the Florida Supreme Court's views on the safe harbor provision should have resulted in a remand to that court for clarification, in addition to the remand of December 4. The court in Bush v. Gore did remand the case instead of dismissing it, but the remand did not include another request for clarification. Louise Weinberg argues that, even giving the court the benefit of the doubt that it acted appropriately in intervening in Florida state law, its actions should be deemed unconstitutional because its intervention was not coupled with any kind of remedy aimed at determining the actual outcome of the election. Limitation to present circumstances. Some critics of the decision argue that the majority seemed to seek refuge from their own logic in the following sentence in the majority opinion: our consideration is limited to the present circumstances, for the problem of equal protection in election processes generally presents many complexities. The court's defenders argued that this was a reasonable precaution against the possibility that the decision might be read over broadly, arguing that in the short time available it would not be appropriate to attempt to craft language spelling out in greater detail how to apply the holding to other cases. Critics, however, interpreted the sentence as stating that the case did not set precedent in any way and could not be used to justify any future court decision, and some suggested that this was evidence the majority realized its holding was untenable. Regardless of whether the majority intended the decision to be precedential, it has been cited by several federal courts in election cases. Accusation of partisanship or conflict of interest. It has been claimed that the majority opinion emerged from conservative Republican justices ruling against Gore for partisan reasons. This claim was made, for example, by Harvard University law professor Alan Dershowitz, who wrote, "The decision in the Florida election case may be ranked as the single most corrupt decision in Supreme Court history, because it is the only one that I know of where the majority justices decided as they did because of the personal identity and political affiliation of the litigants. This was cheating, and a violation of the judicial oath." Chapman University School of Law professor Ronald Rotunda has responded as follows. Not only is that claim inconsistent with the position of Justices Breyer and Souter, it is inconsistent with the position of 3 of the Florida justices who dissented. No justice on the Florida Supreme Court was a Republican appointee, but 3 of them concluded that the recount that Vice President Gore wanted was unconstitutional. 3 of the 7 Florida Supreme Court justices also found an equal protection violation when the manual ballot counters used different procedures to examine identical ballots and count them differently. There has also been analysis of whether several justices had a conflict of interest that should have forced them to recuse themselves from the decision. On several occasions, William Rehnquist had expressed interest in retiring under a Republican administration. One study found that press reports are equivocal on whether facts existed that would have created a conflict of interest for Rehnquist. At an election night party, Sandra Day O'Connor became upset when the media initially announced that Gore had won Florida, her husband explaining that they would have to wait another 4 years before retiring to Arizona. However, both justices remained on the court beyond President Bush's first term, until Rehnquist's death in 2005 and O'Connor's retirement in 2006. According to Stephen Foster of the Manchester Grammar School, on the eve of the election Sandra Day O'Connor had made a public statement that a Gore victory would be a personal disaster for her. Clarence Thomas's wife was so intimately involved in the Bush campaign that she was helping to draw up a list of Bush appointees more or less at the same time as her husband was adjudicating on whether the same man would become the next president. Finally, Antonin Scalia's son was working for the firm appointed by Bush to argue his case before the Supreme Court, the head of which was subsequently appointed as Solicitor General. Various ethics experts have asserted that there was no significant conflict of interest for Justices Clarence Thomas and Antonin Scalia. Recount by media organizations. In 2001, a consortium of news organizations, assisted by professional statisticians, NORC, examined numerous hypothetical ways of recounting all the Florida ballots. The study was conducted over a period of 10 months. The consortium examined 175,010 ballots that vote-counting machines had rejected. In each alternative way of recounting the rejected ballots, the number of additional votes for Gore was smaller than the 537-vote lead that state election officials ultimately awarded Bush. Under the strategy that Al Gore pursued at the beginning of the Florida recount filing suit to force hand recounts in 4 predominantly Democratic counties, Bush would have kept his lead, according to the ballot review conducted by the consortium. Likewise, if Florida's 67 counties had carried out the hand recount of disputed ballots ordered by the Florida Supreme Court on December 8, applying the standards that election officials said they would have used, Bush would have emerged the victor by 493 votes. On the other hand, the study also found that if the official vote counting standards had not rejected ballots containing overvotes, where a voter selects more than one candidate in a race where each voter may only choose one candidate, a statewide tally would have resulted in Gore emerging as the victor by 60 to 171 votes. These tallies conducted by the NORC consortium are caveated with the statement, but no study of this type can accurately recreate Election Day 2000 or predict what might have emerged from individual battles over more than 6 million votes in Florida's 67 counties. Florida also received an additional 2,411 overseas ballots after the 7 p.m. deadline on Election Day. Florida officials rejected these overseas ballots, mostly from members of the United States Armed Forces. By rejecting those ballots, Florida provided Gore a 202-vote lead in the state. The United States District Court for the Northern District of Florida on December 8, 2000, overturned these rejections and ordered that all federal write-in ballots previously rejected be counted. The effect of these additional overseas ballots provided Bush with a 537-vote lead in the state. The ruling also noted, service personnel give up many things when they enter the military, including the free exercise of some civil rights enjoyed by civilians at home. The sacrifice should not go beyond the surrender of rights that are incompatible with military duties. These men and women of our armed forces should be able to expect as much and no less, because of their induction into military service, than those of us who remain at home pursuing normal activities. It certainly would appear unnecessary that our soldiers and sailors and merchant marines must make a special effort to retain the right to vote. The subsequent analysis revealed that black majority precincts had 3 times as many rejected ballots as white precincts. For minorities, the ballot S.
Please subscribe and thanks for watching.